Welcome to the show. I am your most humble host, Daniel. I'd like to first off welcome all the new subscribers to this channel. Thank you so much for your support. But let's keep going, guys. Let's get up to that 500 subscribers before the end of this year. I know we can do it. If we made it this far, we can keep going. And I would like to make this channel something that people, a place where people can come to and enjoy watching video content. Excuse me. I hope that you new guys, I hope that everybody on here is enjoying the court content. If there's a judge that you want to see on this channel and I can rebroadcast it, please let me know. I'll be glad to try it. Okay, so today is the UK Supreme Court. Sorry about that. So today is the UK Supreme Court, which is always something that's interesting. So let me share screen. It looks like this is going to be pretty old. So let me make this bigger. Yes, I'm here. I'm going to be watching comments.
Hearing in the appeal, Forbes and others, and Scotiabank, Bahamas Limited.
Yes, Ms. Rowe.
Good morning, Lords. My name is Crystal D. Rowe, QC.
Yes.
I appear along with Ms. Sid Ferguson, appearing on behalf of the appellants.
Yes.
Jerome Forbes, North Andrews Food Services Limited, and R&R Holdings Limited. My learned friend, Mr. Matthew Slater, appears on behalf of the respondent, Scotiabank Bahamas Limited. We are before you, my lords, on an appeal of a decision of the Court of Appeal of the Commonwealth of the Bahamas, a decision that was made on the 4th of July, 2018, arising out of an assessment of damages by the lower court, specifically the late Senior Justice Isaacs, and that assessed judgment was the 22nd of June, 2016. By this appeal, my lords, the appellants are inviting the court to set aside the judgment of the Court of Appeal and also set aside the lower court's assessment of damages for the reasons which I shall now elaborate on. In the course of the time, my lords, that have been allotted to me, I shall endeavor within the 90 minutes prescribed to provide my oral submissions in two parts. The first part, my lords, shall be for the purpose of demonstrating, or in an effort to demonstrate to the board, why we say the Court of Appeal's decision ought to be set aside and why the lower court's decision ought to be similarly set aside. And then in the second segment, if I may refer to it as that, we shall be endeavoring to demonstrate to the board the appropriate or reasonable amount which we say the board ought to exercise its discretion to substitute as the damages for the appellant's claims in the place of the award so set aside. And so, Lord,
Can I ask, is Mr. Forbes here?
I ought to have my apologies, Lord. Mr. Forbes is here.
Well, he's very welcome to come further forward if he would like to.
Jacket off, my lord. See, is adjusting to the temperature.
We'll be sanguine about the...
For us, it was rather cold outside, and then he walked in,
Yes.
and it was something completely different. So with your leave, he shall not put his jacket on.
That's fine.
I'm obliged. And so, my lords, if I may refer the board first to the written case of the appellants, which is at page 618. And it certainly is not my intention, my lords, to follow this in any particular strict detail, but I will reference it from time to time as I go through my presentation. Specifically, my lords, at page 620, there's a segment of my case entitled Part 2, and it is an effort to describe what we deem to be some underlying material relative to our submissions that both the Court of Appeal judgment and the lower court award should be set aside. Foundational material, if I may refer to it as that, and that is the indication that the appellants were involved in business enterprise that involved essentially two sets of clients. We refer to them, well, the evidence bears out that there were the Paradise Fisheries clients, and there were the J&J Seafood and Phil's clients. And this is material, my lord, it will be material when we get to the Court of Appeals decision and some of the findings that were specifically made relative to certain grounds of appeal that had been advanced. So if I may take the board to electronic bundle, page 16. Tab 16, sorry, page 228. Essentially, lords, I am referring or drawing the board's attention to these two tabs, 16 and 17, pages 228. First of all, these are representative of certain bank statements that were before the court.
But they're not actually bank statements, are they?
No, my lord. There were bank statements before the court, and what transpired was essentially the documents that are at this tab, 16 and 17, are documents that were prepared by the appellant's accountant.
From the bank statements? From
the bank statements. During the course of the trial, it was noted that the bank statements were not of the best copies, and so everybody subsequently referred to these documents as the bank statements. If I might add, there was never any point taken as to their lack of accuracy or anything of that sort.
Well, these just represent the information given by the bank statements, is that right?
Correct, the transactions.
Yeah.
And the closing balances were identical to the information that was in the actual bank statements. And of course, the bank statements were presented by the respondent. So essentially, at 228, this is a statement in the name of North Adams Food Services Limited. And if you scroll to the end of this document, which would be page 35, you see that there is a closing total debit of $4,414,388.86. So if we then move to the other, which is at tab 17, page 237. Again, this is a separate account, and I ought to have indicated, my lords, that the first account that I referred to, you will see in the evidence as having been the account number 5183. And the second document, which is labeled seafood, is in respect of account number 5136. And you see that both bank statements, if I may loosely refer to them as such, represent roughly a period of exactly 1 year prior to the freezing of the accounts. And again, if we scroll down to the end of the second bank statement, you see that there is a closing debit amount of $1,935,426.96. Essentially consistent with the appellants had indicated in their witness statement, and that is at page 147, if we may scroll back to that document, specifically paragraph 15, so page 147. You see that at that point, the deponent, Mr. Forbes himself, is indicating generally the clientele that the appellants provided products for. He indicates that over its years of operation, the plaintiffs have developed a loyal and continuous customer base. The plaintiffs' local customers have included such entities as Paradise Fisheries, Heritage Seafood, Phil's Food Services, Compass Point Doctors Hospital, John Shea Group of Companies, Nesbitt's Restaurant, and D&C Takeout. So he gave a broad overview of his client base. During the course of the proceedings and the evidence in chief of Mr. McDonald, who of course was the appellant's accountant, additional evidence was given as to, number one, the nature of the business being conducted by the appellants, the awards that were being sought in respect of this business, and specifically the accounts that, if I may loosely say, were attached to the particular business being conducted by the appellants. And if I may take the board, firstly, to page, and this is a reference to the transcript itself, page 478. This is, sorry, this is the evidence in chief of Mr. McDonald. And if I may lay the foundation, the references that I will take the board to, then I would say the next 3 or 4 of them, is for the purpose of demonstrating that in the course of the evidence in chief of the accountant, he gave evidence as to these particular clients, and he attached the business of these clients, the appellant's business, with the 2 accounts that I just referred the board to. So there is one such reference at lines 28 to 32. And this is where he's referencing both sets of business, and he says it's in response to a question that I posed to him at line 26, and he says, yes, there are only 2 or 3 major accounts here. That's J&J Seafoods. I see they changed their name to Heritage and Phil's. Phil's is a client of mine, and so I know the activities of Phil's. And Paradise Fisheries, sorry. So Phil's and Heritage, I think the name is now Heritage, and those would be the other 2 suppliers Jerome would supply with seafood. And if we were to go over the page, sorry, same page, 478, lines 7 to 19, there's similar evidence coming from Mr. McDonald identifying these clients, where he says at line 7, question that I put to him. You spoke about Paradise Fisheries bills as a source material for reviewing the entries on the seafood account.
Sorry, I'm not with you. Where are you?
So we're at page 478.
Back to 478.
But we're going back up to line
fine.
7.
Oh, yes, I see. Thank you.
Where I pose a question to the witness, and
Yep.
then he's answering at 11. Well, I'll go back to 7. You spoke about Paradise Fisheries bills as a source material for reviewing the entries on the seafood account. The entries on the North Andrews Food Services account, are you with me? I'm referring to that particular statement that I had referred the board to earlier, the North Andrews Food Services account, and his response is yes. I say, how would you have verified the entries on that account? And he says, the same process. What Jerome Forbes did on that account, he would sell to other suppliers, Phil's and JJ Seafood, other suppliers locally, and he would get $2.50 per pound for those activities. So those activities will reflect any other seafood activity other than Paradise Fisheries. So again, You may recall that I identified the North Andrews Food Services account and the witness in this portion of the evidence is saying.
Forgive me,
that,
Mrs. Rowan.
Yes.
What point is being made by reference to this evidence? What is the point that you want to...
When we get to the Court of Appeal's decision, Lord, one of the grounds of the appeal before the Court of Appeal was that the learned judge in his assessed award, in accepting Mr. Raming's assessed award of $89,000, that $89,000 award only related to the Paradise Fisheries business. So one of the grounds of appeal was that that award was erroneous because it did not take into account the J&J Seafood business. The court made a determination that that ground was wholly without merit because the evidence never demonstrated, number one, that there was any other business other than the Paradise Fisheries business. And number two, that the evidence was not presented in a way that the business was connected to these particular accounts. And so you see that in this particular extract alone, Mr. McDonald is, having been referred to the North Andrews Food Services account, is saying that the Paradise Fisheries, sorry, not the Paradise Fisheries business, the J&J Seafood and Phil's business was conducted through that account. So the purpose of going through this evidence at this point was to lay the foundation for when I get to the Court of Appeal's rejection of that particular ground of appeal. What will be demonstrated, my lords, is that because the case, the overall award of damages that were sought was split into two separate heads in respect of two separate sets of business. And the award only awarded for one set. And that was a ground of appeal, and the court said no. There was no evidence to suggest that there were two sets, and certainly there was no evidence to link the business so identified to any particular business account.
Can I just ask some really basic questions? Are we talking about the Paradise Fisheries being operated through bank account number 5136 and J&J Seafood being operated through account 5183?
Correct.
And there were financial statements for Paradise Fisheries, we've seen them.
Yes.
There was only the bank account information for J&J Seafood.
Correct.
Thank you.
Correct. And indeed, the Paradise Fisheries activities were only reflected, the only activities reflected in the financial statements.
So
what?
The two statements we looked at earlier, tabs 16 and 17,
Yes,
they both relate to the same account, do they?
no, those are two separate and distinct bank accounts. The first at 16 is 5183, and the second at 17, 5183 would be with the $4.1 million balance.
Yeah.
And the second at tab 17 with the 1.9 is 5136.
Right, okay.
So the former is the J&J business, the second is the Paradise Fisheries business.
That's what I thought. So going back to the transcript,
Yes.
at line 7 to 9, you spoke about the Paradise Fisheries bills as a source material for reviewing the entries on the seafood account. Now, what account's that?
The seafood account would be the 5136. You may recall that as I was taking the board to it, there was a reference at the top that said seafood.
They both have a reference to seafood, but one's printed and one's handwritten. So the printed seafood.
Yes, the printed seafood.
And then the question goes on. The entries on the North Andros Food Services account, now that account is...
That's at tab 16.
That's 5183?
Yes.
Okay.
And so you see that in that response, my lord, he's connected that 5183 to the business of J&J Seafood and Phil's.
Right.
He says everything conducted on those accounts are other clients other than Paradise Seafood, Paradise Fisheries.
Okay, thank you.
So now there are a number of references of that nature, and I'm wondering whether I can just provide the court with those references. They're of the same nature. So on page 477, you see similar evidence where the witness is connecting the Paradise Fisheries business to account 5136, and the lines are 11 to 23.
What page was that?
Page 477.
Thank you.
Additionally, page 454, lines 8 to 12, to 14, sorry. finally, page 446, lines 1 to 3.
All the evidence of Mr. MacDonald's? Yes. And how did this exactly undermine the defendant's expert?
Well, this evidence, I wouldn't say that it related to the defendant's expert's evidence. This was insofar as separating the nature of the claims into these categories and attaching them to those accounts. There is...
Well, they weren't pleaded as separate claims, were they?
They were the business is being operated through the accounts.
They weren't pleaded in your particular claim as separate claims?
No.
And they weren't identified by Mr. MacDonald as being separate in his global figure?
They were.
Well, they were in his account, but not in the global figure.
They were. When you go to his, there is a summary in his assessment. His assessment is at tab 18. And the summary of his assessment is at page 267. Essentially, by the time we got to the assessment, there were only two heads of loss that we were assessing or considering. The overall claim was broken down into these two heads. And in his evidence in chief, as he began his discussion on both of these amounts, the amount for $2.1 million and the amount for $1 million, he started off by identifying the business that it related to and the account that that business was transacted through. And you will see that the references that I just provided, you will see that evidence. Whereas he explains, first of all, the $2.1 million, he indicated that that is in relation to the business being conducted through account 5183, he says that. And then at the beginning of his explanation of the assessment of the $1 million claim, he also indicates that this is the business being conducted through accounts number 5136, sorry. And so in the body of his evidence, not only is he identifying these clients by name, but also attaching them to the various accounts. And as I'd indicated, when we get to the Court of Appeal ruling, the Court of Appeal made quite a definitive determination that there was no such evidence at all, and that the claim had not been presented in that manner. That was the sole basis upon which that ground was rejected. Pardon me? Of the Court of Appeal's judgment. If we go to the Court of Appeal's judgment, and that is at tab 5, it starts at page.
But if we look at page 249, we have Mr. MacDonald's minimum, average and maximum figures. There's a minimum, average and maximum figure for lost profits.
Yes.
How does that relate to the total of the two figures we've been looking at?
Well, at this page of the report, he provided a range of where the awards would likely fall. If you look at the statement of claim, at that point, the degree of specificity that ultimately came had not been provided, and that range is what had been pleaded. When you get to the end of the report is when he specifically does the assessment and comes down with the exact amount as to the awards of damages that he was proffering.
This is the historical gross margin.
Yes.
And
so if I followed the Court of Appeal paragraph that Her Ladyship had requested that we go to.
Thank you so much.
It's at page 36, and it is final paragraph, so page 36, at the very end. And it says, the appellants also complain that the judge failed to differentiate the losses suffered by each company, which of course is not the true nature of the complaint. But in any event, what goes on to say, These contentions are contrary to the evidence that was before the judge at first instance, as the first appellant's evidence did not distinguish between the Scotiabank accounts and the business to which they were connected. Furthermore, Mr. McDonald did not make reference to the appellant's business by Scotiabank account numbers. McDonald referred to loss of profits only for the Forbes Group of companies. And this particular ground of dismissal of the appeal continues at paragraph 37, where that point is elaborated upon. If we could go to that paragraph. Paragraph 37, the Court of Appeal then said, the second, third, and fourth grounds of appeal will be considered together. In essence, the appellants complain that Isaac Senior Justice erred by failing to differentiate between the losses resulting from the interruption of the Paradise Fisheries business as distinct from the losses associated with the J&J seafood business. The appellants contend that Isaac Senior Justice did not differentiate that Paradise Fisheries operated its business account through Scotiabank account number 4116, while J&J Seafood and Phil's Food Services operated their business through another Scotiabank account, 5138. This failure, they say, resulted in him making an improper award of damages with respect to the appellant's J&J Seafood business. And in fact, we said that there was no award for the J&J Seafood business, not that it was inappropriate. These contentions are contrary to the evidence that was before Isaac's Senior Justice. The appellant's statement of claim lacked any reference to the nature of the business that was conducted through either of the two Scotia accounts. Also, the first appellant's evidence did not distinguish between the Scotiabank accounts and the business to which they were connected. Furthermore, McDonald did not make reference to the appellant's business by the Scotiabank account numbers. McDonald referred to loss of profits only for the Forbes Group of companies. Isaac Senior Justice made clear reference to the Scotiabank accounts, which were at tab 12 and 13, which are the same accounts that I had referred the court to earlier, of the appellant's trial bundle. The following passages are taken from the judgment, and they quote the judgment of Senior Justice Isaacs, and then go on to paragraph 40 to say, from this, it is apparent that these grounds should fail as they are without merit.
So they're saying the judge did have regard to both sets of accounts.
Well, he referred to them, but essentially they are saying that, and they're correct in saying that he did not identify, as the evidence clearly did, that there were two sets of business being operated through the two bank accounts. One, in the year before, showed activity of over $4 million, and the other showing activity in the amount of almost $2 million. It is the $4 million account to which there was no reference made by the judge, and to be quite fair to the judge accepted the assessment of $89,000, which related to the Paradise Fisheries business only. And the ground of appeal, therefore, was that the assessment is also wrong, because to the extent that not to the extent, the fact that it only related to the Paradise Fisheries business means that there's been no recovery at all for the J&J Seafood business, which clearly existed.
But was it put to the judge that if he accepted the Raming methodology, he would have to make an allowance for the J&J Seafoods account? Admittedly, that was in deficit. No, that was the one in credit, isn't it? One of them is in deficit. But was it put to the judge that if he preferred the methodology of the bank's expert, he would have to make a further allowance for the other business?
Indeed it was. The claim from the outset was presented in that respect.
Now, that's Mr. MacDonald's evidence, but was it said if you, Judge, prefer Mr. Isaac's approach, then you've still got to increase his award?
Well, it certainly arose in Mr. Raming's cross-examination, because Mr. Raming accepted that during the time that he did his report, he was of the erroneous belief that the financial statements covered everything. And so he confirmed during the course of his cross-examination that it was only after he had met with Mr. McDonald that he recognized that the financial statements that he relied upon only covered the Paradise Fisheries business. Then he went on to indicate that he did not do an assessment in respect of the J&J Seafood business.
Because you said there was insufficient material to do so.
He said that he didn't have the material to do so. Bear in mind now, he prepared this report with very limited time constraints. He, again, prepared the report on the understanding, erroneously so, that the financial statements that he had covered everything. It wasn't until he got to the point of cross-examination that he was then made to understand that, no, the financial statements only covered the Paradise Fisheries business. And so he conceded that he did no assessment at all for the other set of business.
Because he was saying you need financial statements to do a loss profit calculation.
Pardon me?
He was saying you need the financial statements to do a loss profit calculation. We don't have that.
No, we do not have financial statements for, well, all we have are the bank statements to which I referred the court to. But he took the view, well, I don't know that at the time of his assessment he took that view. The reality is, at the time of his assessment, he thought that he was assessing everything. And he says that. He believed that the financial statements represented all of the activities of the appellants. And so as he sat and he did that assessment, he did it with the understanding that he was covering everything. And so the $89,000, when he assessed it, was intended to cover everything. So it was during the course of the evidence that he then recognized, or was made to accept, that the Paradise Fisheries financial statements did not include this additional business. And this is one of the reasons why we say, given that he accepted that, the learned judge of the court below ought to have made some adjustment to his award.
How does he know what adjustment to make? Was there a schedule of the expenses that were related to that income into the bank?
Well, what there was the evidence both of the appellants and Mr. McDonald that the manner in which this account was operated, I'll backtrack and go to the manner in which the business was operated. The accounts, both of those accounts were maintained in Andros. The money was sent from Nassau to those accounts for the specific purpose of purchasing seafood.
No, but that doesn't answer my lady's question. Was there a figure that the judge could derive from the evidence given by which he should have increased his award? Your point is the judge was obliged to reflect the concession made by the defendant's accountant in his award. But was there a figure canvassed before him on which evidence was given by which he could have increased the award to reflect that circumstance?
Well, the report that was advanced by the accountant provided an assessed award for that amount, for that head, independently of the amount.
By the claimant's accountant?
By the claimant's accountant, correct. Yes, and in
What was
addition to
that
that,
figure?
that was the $2.1 million claim. Because as you would note from the reports, the volume of business, the volume of purchases was significantly greater in respect of that business than it was for the Paradise Fisheries business.
So
The only documentary support for that was the bank statements.
The bank statements, correct.
And Mr. Rahman's evidence was you simply can't construct a claim of this nature just from bank statements.
Well, he expressed the view that bank statements could be a source material in certain circumstances.
Yeah.
And the circumstances that he specifically gave were if you could account for the inflow of the money into the account to ensure that, you know, the money that was going in was for the specific purpose that it is being presented. And there was evidence to that effect, that these accounts, and this evidence came not only from Mr. Forbes, but also from the accountant, that these accounts were exclusively for the purpose of purchasing seafood. There was no other business operating through these accounts. So all monies that ran through that account were for the purpose of purchasing seafood and were in fact utilized for that purpose. So the accountant of the appellants utilized also that material, the bank statements, as being reflective of the level of purchasing that occurred in the 1 year prior to the freeze. You see the volume of business that was being transacted as it related to that particular business.
But it wouldn't show the profit of the business, would it?
Well, this is one of the submissions that were made to the learned judge, and regrettably, the manner in which the bank statements are treated by the learned judge in the judgment demonstrates that, with respect, that the manner in which the claim was presented was not received. And I'll say it this way. The evidence was that there was a 15% rate of return on all of these transactions, ultimately, after taking into account expenses and the like. And so, if the amount on the bank statements is reflective of the amount of investment for that period, the application of the rate of return would then give you an estimated amount for the profit.
But what's the evidence of the rate of return, apart from what Mr. Forbes says, or Mr. McDonald says?
Mr. McDonald gave evidence of the rate of return being 15%.
That's
He said
historical.
that.
Isn't
Pardon
it?
me?
It's a historical
It is
figure.
historical,
So
yes.
it doesn't tell you what it would have gained in the period of the freeze.
Well, it's historical up to the date of the freeze.
And
So-
one doesn't know what would have... simply taking the past figure doesn't tell you what would... It doesn't allow for different trading conditions in the period of the freeze.
Well, in estimating the profit as a result of the freeze, the process would be to use this historical data, both of the volume of investment and the anticipated rate of return, to which there would be a result, and which may or may not be awarded. It could be adjusted, it could be discounted. But you see none of this occurring, notwithstanding the fact that it was presented.
Was there audited material as to what constituted the expense of the businesses we're concerned with, as opposed to expenditure on personal matters?
In the financial statements,
In the material used by Mr. MacDonald?
the expenditures were set out as it relates to the Paradise Fisheries business.
So they're
In the,
I'm looking at it now, I think.
yes, that would be page 257.
Speaking for myself,
They are, the evidence was that the expenses were relatively nominal, given the fact that the business essentially was ran from Mr. Forbes' home office.
One would have to drill... Sorry. I wanted to hear the end of the sentence. I'm sorry, I thought you'd finished.
I was saying that the evidence was that the expenses were rather nominal, all things considered, and constant, given the fact that the enterprise was run from a home office of Mr. Forbes. And this is the reason why, as we were talking about methodology, as I was cross-examining Mr. Ramming about methodology and his concerns relative to the approach of the sales approach, he ultimately conceded that given the relative consistency of those expenses and having regard to the significantly higher sales numbers, expenses were not an overriding concern in the process of assessment.
But I don't see how the judge could get to this point, because even the loss of profits statement, which he had, was prepared by the company's management. Mr. MacDonald says so. What documentation did he have to form any view for the purposes of the 15% profit assessment, or indeed anything else about J&J business?
Mr. MacDonald or the court?
Mr. MacDonald, first of all, because Mr. MacDonald asserted it, and secondly, the court. You'd expect to see a file of documents, for example, but as far as I know, there wasn't anything.
Well, it was presented as the result of his work, and I would add that it wasn't
Mr. MacDonald's
of
work.
Mr. MacDonald's
But
work.
Mr. MacDonald's
And
work
it-
was entirely based on what he'd been told by the company. He says that.
And what he had himself gathered over the years.
Well, it's
And that's
unaudited
something-
as to the main loss of profit account. It
As to
says
the-
unaudited.
Yes. And that was the work that he had done in preparation not only of the financial statements, but also in preparation of his report. I was going to add that the rate of return, the position that he had taken as to the rate of return of 15% was not something that was challenged not by the respondent, and it was presented essentially as evidence that was unchallenged.
How
And so-
was Mr. Raming or the judge going to be able to assess the 15% figure without any documentation whatsoever?
Well, my lord, as I'd indicated, it was presented as being the position of Mr. MacDonald based on his calculations, and it was accepted as such.
Well,
It
you
was
say
not
it's accepted.
challenged.
You
Pardon me?
say it's accepted. Earlier you said it hadn't been challenged. Which is the position?
Well, it's both. It had not been
With
challenged.
respect, I don't think it can be both.
It's,
If it hasn't been challenged because, as my Lord points out, there's simply no material on which to test its veracity or accuracy, that doesn't mean to say that it's accepted by the respondent.
well, I'll
I mean,
put it
the
this way.
obligation is on the claimant to produce evidence which will allow the judge to make an assessment. And absent material on which he can make a reliable assessment, then surely the judge is entitled to disregard it.
Well, I take that point, my lord, but if you look at the assessment, there's no reference to it at all, even though it had been presented. And so we cannot even say that it had been disregarded. It's just a complete omission. If there had been some element within the judgment that demonstrates that it had even been considered,
Well,
if the learned judge had
Does
said,
that
I've
mean
considered
that,
it.
does that mean,
no,
therefore, that if the judge had said it has been claimed that 15% is the appropriate figure, but there's simply no material on which to judge the accuracy of that claim, and therefore are not disposed to make a finding in favour of the claimant, that would have been that?
Well, certainly. But before we even get to that, had the judge even condescended to this claim at all, to this business at all? The judge accepted the $89,000, which undisputably relates only to the Paradise Fisheries business, as being a thorough analysis and as being reflective of all of the loss. So not only is the judge not saying that there's insufficient material for me to assess the award, the judge does not even condescend to the claim. And it would appear as though the judge has accepted the $89,000 as being reflective of all of the economic activity, as Mr. Raming had initially himself done. It would be entirely different if the judge had said, I recognize that this $89,000 only speaks to the Paradise Fisheries business. I recognize that the appellants are also making a claim as it relates to the J&J seafood business, but I reject that claim because I find it as being unsubstantiated. There's nothing of the sort.
But Mr. Raming had both sets of bank statements, didn't he?
He did.
So
He did.
Isn't the point that he was making simply that he didn't know it was a separate
Correct.
So
He
he did
did not know that that claim existed, and so therefore,
I wasn't quite there, but isn't the point that he was making, and I'm just trying to find his answer, that he simply didn't know that there was a separate customer? He assumed it was all Paradise.
he assumed that it was all Paradise
So
Fisheries.
he's taken the right
And he-
figures in.
He's taken,
The right figures in. He's taken the figures from both sets of bank statements.
no, he hasn't. Bear in mind now, when he assessed Paradise Fisheries, he assessed it based on the financial statements.
Yes.
And those financial statements, because they relate only to Paradise Fisheries, they would then only have as an underlying source the bank statements for 5136. Because remember, 5136 is exclusively Paradise Fisheries. And so therefore, when Raming looks at that financial statement, he is unequivocally only looking at the Paradise Fisheries business. And his conclusion can only relate to the Paradise Fisheries business. And I take His Lordship Kerr's point relative to the assessment of the J&J seafood business, but as I've indicated, there's nothing in the judgment that even indicates that the court had it in its contemplation at all, favorably so or otherwise. And certainly the appellants would be entitled to know how has that claim been addressed by the court, if at all.
Did you do written submissions?
We did.
Have we got them?
Extensive.
Have we
We
got
don't
them?
have them, but I do recall the last time I was here, I sent them subsequent, and I can do that again. There were extensive submissions made as to both sets of claims and the basis for both sets of claims, and yet the judgment does not at all condescend to the second claim. And as I've indicated, if it were treated unfavorably, then fine. But it hasn't been.
The judge sets out the evidence of Mr. Raming and repeatedly makes the point that Mr. Raming is saying there's no supporting evidence for the lost profit claim made by Mr. MacDonald, and he accepts the evidence of Mr. Raming. So isn't he thereby accepting Mr. Raming's evidence that there simply isn't the supporting evidence for this
But
claim?
bear in mind now, Mr. Raming did not give any evidence as it relates to the second claim. Mr.
Indeed.
Raming
He
gave
said,
evidence
he said
solely.
the only thing I can look at are the financial statements.
Correct.
And the other material you're referring me to is just bank statements and
Correct. And
conjecture.
again, I reiterate the point that Mr. Ramming was of the view, and he is saying, I don't have any additional information.
Yes.
But he worked on the premise that the financial statements covered everything.
But it wouldn't
And so
make-
in his mind, as he assessed that amount, he contemplated that he was assessing an amount for all of the economic activity, wrongfully so.
Yeah. But when you put to him, well, there are other sums to be taken into account, Mr. MacDonald's 2 million figure, he's saying, well, there isn't material to support it.
He said he did not do an assessment because he did not have the material to do so.
And that's what the judge is accepting.
Well, the judge actually hasn't done that with respect.
He's
The
accepted
judge
Mr. Raming's
accepted 89,
evidence over that of Mr. MacDonald.
as it relates to the $89,000 assessment.
So,
Because you have to go back to the starting point, which is that $89,000 assessment relates exclusively to the Paradise Fisheries business. And so the judge is accepting that as being reflective as of a proper award for the Paradise Fisheries business. So I think it might be appropriate for me to move to even that $89,000 assessment, because we say, even as it relates to the Paradise Fisheries business, it is grossly inadequate, having regard to what the evidence was on cross-examination. And that, I think the board takes the point that the Paradise Fisheries business was the only business reflected in the financial statements. And
No, I'm not sure I understand this at all. The evidence of Mr. MacDonald, as I understand it, is that the bank statements in the name of North Andros Food Services Limited were actually statements relating to a business carried on by Mr. Forbes personally, although he had a personal bank account, which wasn't before the judge. But that account, that's 5183,
yes.
was his personal trading activity, and North Andros Food Services Limited's own trading activity was carried on through the other account, 5136.
5136. That was an account in the name of North Andros Food Services Limited. And that is exclusively the Paradise Fisheries business, correct?
Well, as I read I may be wrong, as I read the evidence, I was under the impression that the Paradise business was one carried on by Mr. Forbes personally.
Originally, the evidence that came from Mr. MacDonald is that in the earlier stages, 2001 to 2006, Mr. Jerome Forbes operated the Paradise Fisheries business in his own name. And the evidence was that the respondents, by virtue of the volume of the activity, invited him to incorporate that business, which he did in 2006. And so there's a change in the name of the account from Jerome Forbes Trading as North Andros Seafood to North Andros Food Services Limited Trading as North Andros Seafood. So this is why you have the discrepancy in the names, because at some point the respondent had invited Mr. Forbes to regularize the activity because of the volume of the activity. But that is all exclusively the Paradise Fisheries business. And as it relates to that business,
That's a 2 million figure, is it?
that's the 2 million figure. And that is the business where we do have the financial statements.
that's the 1 million thing.
Well, 1.9, I figured his lordship was rounding off.
Yeah.
Are you referring, my lord, to the balance or to the amount being
Oh, I
claimed?
see. That was a kind of profit figure. Yeah.
I assume it
Yeah,
was the amount
1.9
in
million
The bank statement
in
figure.
the bank statement.
debits.
To be clear,
2 million
the
credits.
amount being claimed was the 1 million, and the balance on that bank statement was 1.9. Yes.
But is it correct to say that Mr. Raming took no account? Because at page 191, at the end of paragraph 3.28, he refers to the loss attributable to the closure of Jerome Forbes Trading as Forbes Seafood. 191. Then at the end of 3.28, two-thirds down the page, refers specifically to the loss attributable to the closure of the Jerome Forbes trading as Forbes Seafood.
Those are claims that did not form a part of the assessment. Those were claims, they were additional claims. They're reflected in the report, but they were withdrawn. And this is the reason why those lines exist through the page. The claims that went to assessment were only the loss of profit as it relates to these two business activities. I was about to take the board to the error that we say exists even in the $89,000 assessment for the Paradise Fisheries business. And that is insofar as Mr. Rami accepted that the amount was assessed by reference to the financial statements. He also accepted that the manner in which he arrived at that assessment was by use exclusively of the net profit, net income figures within the financial statement. And at the time that he did that assessment, he had no awareness of the fact that in the cost of sales figure, there was commissions income that was attributable to Mr. Jerome Forbes. Now, there was extensive cross-examination on that point, and ultimately, at page 547, after we had belabored the point, Mr. Rami ultimately accepted that that amount, the cost of sales amount, that includes the commission to Mr. Forbes, is loss that Mr. Forbes would sustain as a result of the freeze. Now, the difficulty we have with the assessment is that when you look at those cost of sales amounts, that is a significant amount of income that, but for the freeze, Mr. Forbes had been taking home. But what is not reflected in that $89,000 figure.
Can you help as to where you laid the ground for this claim? Is it in the particulars of claim that Mr. Forbes's own commission is being claimed? Is it in the financial statement?
It is in the financial statement.
Well, we know
it starts in the particulars of claim, in
Right.
the sense that what has been claimed is loss of profit as well as loss of
Right, so could you give me the page reference in the particulars of claim,
The
please?
statement of claim is at, let's see, I think it's tab 13. What's the statement of claim? '64. So the statement of claim starts at page 64, I'm told.
It's page 75, isn't it?
In the particulars,
Yeah.
you speak of the loss of both revenue and loss of profits. And then when you go to the evidence, well, it pleads that the evidence of such loss would be adduced by expert
Which is the
evidence.
paragraph where Mr. Forbes's own commission loss is pleaded?
It's not pleaded in terms of commissions, it's pleaded in terms of loss of revenue.
But his personal one?
His
He's
personal
the first
claim.
plaintiff, is he?
Pardon me?
Is he the first plaintiff? Yes.
He is, yes.
And,
And then when you go to Mr. McDonald's assessment,
well, I'm still looking for this. We've got a plaintiffs in the plural claiming for loss of revenue and profits. That's it, is it?
That's it.
And we're told in paragraph 3 that the second and third plaintiffs operated businesses involved in the fisheries industry. Well, was it even pleaded that Mr. Forbes personally was carrying on a fisheries business?
that was the evidence.
Yes, well, I'm asking if it was
this-
pleaded, if it's part of your claim.
Let's see.
He's mentioned, but...
I suppose paragraph 10, I'm also personally involved.
Yes, I was about to refer to that. My junior had just pointed that out to me. And then if you look at the very beginning of the lower court's judgment, the business enterprise is presented as having been conducted collectively by the plaintiffs, thereby following that plea. And I was about to say, Milady, that
Well,
when you go to the evidence...
Well, if you look at page 75, you see the claim actually made for the first plaintiff. The first plaintiff, by reason of the breach, had to seek alternative financing for the completion of his residence
Right, that's in relation
and
to the
has
breach of the
suffered
mortgage
loss and
contract.
damage as a result thereof. And then the second and third plaintiffs had to seek financing to facilitate the continuation of business operations and have suffered loss and damage.
But I think if you look at 2, it's been amended, hasn't it? So
Yes.
it had originally only claimed for the second and third plaintiffs' loss of profits, and now it's all the plaintiffs' loss of
Yes.
profits.
So it's profits and
Before
revenue.
where you were, just the page before, a little too.
But there's no separate commission claim.
Well, the commission claim is what was been described in the pleadings as revenue. It was exclusively profit that the corporate profits, corporate parties were claiming.
Okay, so
The
that's...
loss of revenue is what the first plaintiff was claiming.
It is not spelled out, put it that way, in the particulars of claim.
That is specifically commissions.
Can I go straight to the report and ask you where it's spelled out? I know that it's part of the deduction made from the takings of the business that's dealt with in the financial statement.
Yes.
But where is there any greater specificity?
There is. If you go to McDonald's report,
Yeah.
the summary, as you may recall, was at page 267. And then the breakdown of his assessment are on pages 268, 269, and 270. Actually, 268 all the way to 271. And there are 4 pages because they're in respect of the 2 claimed amounts. So if you go to 269, for example, as he's assessing the Paradise Fisheries business, you see that those the last columns, if we start at page 268, those columns are broken down as commissions and gross profit. And then you go over to 269, you see where the ultimate amount that's being claimed is divided into an amount for profit and into an amount for commissions. And that's done in respect of both heads of loss.
Where are you?
Page 269,
Yeah,
that's the culmination of that particular assessment.
yeah.
And then you go over for the other assessment that ends at 271. And again, that $2.1 million figure that was claimed is broken down into commissions and profits, respectively 901 and 1.2. And so to answer her ladyship's question, it is in the assessment where the separation was made as between the gross profit being claimed and the commissions income being claimed.
Oh, I see.
What is the commission being claimed in this column?
In respect of total or
The percentage.
percentage, it is 15% of the
What's
cost of sales amount.
And what's the documentary evidence for the 15%?
That is the evidence that Mr. McDonald gave.
What's the documentary evidence?
I do not think that there was documentary evidence. His specific evidence was that the cost of sale, he having prepared the financial statement, indicated that the cost of sales amount was 85% cost of product and 15% cost of sales.
Where does the 15% come from? Is it a contract or what?
I do believe it was contract.
Where was the
Contractual.
contract? Where was the contract?
It certainly wasn't a written contract, but it was an arrangement that the parties had in the course of their business dealings. That is the amount by way of commissions that the first appellant took home as revenue. Now, the result of that, and I don't think there is, a concession from Mr. Raming that at the time of preparing the report, he did not know that that commission's income existed. And he was prepared, by way of his responses during cross-examination, to concede that those amounts, as existed in the cost of sales, would constitute a loss to Mr. Forbes.
I thought you
But
said
89
you couldn't separate out the personal element from the financial statements that he had.
Well, he never took the position that there was a problem in doing so. He accepted. During the course of the cross-examination, he accepted that that would be a loss.
That would have to make an adjustment to the 83,000 figure.
He
then.
would have to make an adjustment to the
But
89,000.
where's the net gain to your clients? Because one would balance out the other.
Well, the difficulty there is that he awarded a sum of 0 for the first appellant, which means that having accepted, subsequently of course, that there is some loss as a result of the interruption of that business and that activity, there ought to be an adjustment. And he acknowledged that an adjustment would be appropriate. But again, there's no way of knowing how the learned judge received this aspect of the evidence that evolved during the cross-examination, because it's not addressed at all. Specifically, there is a segment in the learned judge's judgment where he deals exclusively with the cross-examination of Mr. Rami. And at no point does he mention these issues. And ultimately, even though Mr. Rami accepted that this particular amount, these commission incomes, which were clearly indicated in the pleadings, in the assessment, the loss of which would be a loss to Mr. Forbes, there's no indication that the court took it into contemplation. And we say that that's another reason, and again, to address it.
I haven't quite got that, and do forgive me, but Mr. Raming was saying he didn't know about the commission arrangement, which wasn't surprising because it wasn't documented. I don't know whether he didn't know about the commission, the rate of commission.
He didn't know of the
So,
commission.
unsurprisingly, he didn't take it into account as something to be separated out.
And we do not hold him responsible for that, given that in the moment, and of course, as an expert, once additional information comes to your knowledge, there ought to be a willingness to address it. And he did indicate that he would accept that would be a loss.
He accepted it would be a separate claim, but he wasn't asked to make the further adjustments to the 83,000 figure that would be necessary to reflect a separate claim for the first plaintiff. And so all that's necessary now isn't it? If that is a point. It's simply a direction that the figure be worked out as between the plaintiffs.
Well, the figure has to incorporate that amount. And he indicated that
It's either the 83,000 or it's taken out of the 83,000. But so far as Mr. Raming's evidence is concerned, it's not additional. It's simply part of the figure. Because he didn't know about the liability on the part of the company.
From an accounting standpoint, he said it's part of the financial statement. It's a part of the process at arriving at the $89,000 that would be awarded to the company. But stepping aside from the accounting analysis for the moment, as income to the first appellant, there's nothing to indicate.
But you didn't ask him what adjustments he would have to make to take out Mr. Forbes's claim and give it simply to Mr. Forbes at 547.
The figures are there.
Yes, but he's done an evaluation for the purpose of producing the 83,000, so he would have to separate out the commission amounts. So that question wasn't put to him.
Well, I don't know if separate out would be the correct terminology. He would have to do an assessment.
I think my lady's perhaps working on the basis that the 80-odd thousand was including the commission. I wonder whether that's the analysis that you're arguing. When we look at the financial statement, as I've understood it, the alleged commission was included in the cost of sales for the company.
Correct.
So it was taken out as an expense in diminishing the return to the company, in reducing the net profit.
Correct.
So as I've understood your argument, maybe I'm wrong about this, it is that there should have been the 80-odd thousand, which is based on the net profit of the company, plus the amount which had been deducted from the company's profits to pay commission to Mr. Forbes.
Indeed, because that is income.
So that would be to add on top of
The 89,000.
Correct. Okay, that's correct, is it?
That is correct.
I see.
And I think from an accounting standpoint, what Mr. Raming was saying was that it's included in the financial statement, so it's taken into account. But it's taken into account in the process of determining what amount of loss the company has suffered.
It's taken into account in a negative sense. It's a deduction.
And in arriving at the loss of the company.
Yeah.
And one of the expenses that the company has is to pay Jerome Forbes.
Yeah.
And so there's no award for Jerome Forbes.
But
And so the 89,000, which is now intended to be compensation for all of the plaintiffs, we say, does not take into account the revenue or the loss of revenue, loss of commissions, if you will, that Jerome Forbes has suffered.
It's a two-stage process, of course. You first establish that it hasn't been taken into account, but then there's the question of whether you can prove it.
Well, it hasn't been taken into account in his assessment. Because bear in mind, he assessed loss of profits exclusively attributable to the company. And so therefore, in that limited extent, it's been taken into account. But to the extent of attributing a loss, as he acknowledged it would be, to the first appellant, that hasn't happened. And so now, clearly, in light of that evidence, there ought to have been, we say respectfully, an adjustment or an award made by the court, and the court was indeed invited to do so by way of submissions, to take into account the loss that has been suffered as it relates to the Paradise Fisheries business by Jerome Forbes, given particularly the fact that the appellant, Mr. Ramming, having now acknowledged that that revenue exists, accepts that that would constitute a loss to Mr. Forbes.
And I'm not sure if he accepts the figure of it. He accepts the principle of it. He accepts the principle, doesn't he?
But he actually, Lady, I would go so far as to say he accepts the figure as well. And here's why I would say that. Because when the question was put to him as to his knowledge of 15% of that amount being revenue or commissions, he said, I now know that.
How could he or the judge verify that figure?
Well, bear in mind now that by the time we get to the point of cross-examination, Mr. Ramming has actually been in communication with Mr. McDonald. And he said that he determined that during the course of those meetings. So he didn't say, when I said to him, do you now recognize that 15% of that cost of sales constitutes commission income? He didn't say, no, I don't accept that, no, I haven't verified that. He says, yes, I now know that. So he accepted that as a proposition. He accepted it. He said, yes, I know that now. I didn't know it then.
But also, in relation to my question, how could he or the judge verify that as a figure?
As a result of the evidence that had been given.
Well, just because Mr. Forbes says it's 15%, or Mr. McDonald
Well, Mr.
says.
Ramming said it was, and Mr. McDonald said it was, and Mr. Ramming accepted. And so the judge is sitting back, and he's heard the appellant's expert say it's 15%. He's heard the respondent's expert accept that it is. And all the respondent expert says is that I didn't know that at the time, but I now know that that 15% commissions income exists in that amount.
it wasn't quite the question put to him, was it? He was simply accepting that if there was a separate claim, it would be a separate head of recovery.
Well, early on in the cross-examination, the specific question that was put to him was whether he realized that 15% of the commission's income, of the cost of sales included commission's income. And he says, I know that now.
Have we better not look at that in the transcript, please?
Yes. I should be able to determine where that is. I know that cross-examination starts at page 541. My apologies, it is 541.
Sorry, 541.
Yes. And it goes on to 547.
Well, it's the particular claim that you made just a moment ago, that he had accepted the 15% that I'd like to focus on.
I'm going to jump to 547.
There's a mention of 15% at 558. I don't know whether that's...
542 line 17.
Well, that's not a figure.
I've just word searched, and the first reference I can find to 15% is on 558, but it may not be the bit you're thinking of.
And he gives an answer at the bottom of 557, top of 558
Yes, that's the end.
of general relevance.
Start at 541. At the bottom page 541. At line 27. Let me qualify this as well. You have to understand this is all I had at the time. I reviewed it. I only have what was provided to me.
Before we go any further, what's the financial statement that he's referring, that he's being asked
The financial
to
statement that's
comment
on page 547 in respect to the Paradise Fisheries business. Remember, this is the statement that was utilized by him to assess the 89,000.
Well, the statement obviously isn't in the transcript, so do we have... Do we have
Oh, it's
Page
at-
257.
257. Oh, thank you. Right.
Do you want to go to that or should I continue?
No, it's just so I can follow what he's talking about.
So that is what I referred him to. And he says, continuing with 1.541, at cost of sales numbers, I understood it represents cost of sale, cost of product. So if you're going out there and you have to purchase a product from smaller scale fishermen, they're going to sell it to you for a price. Any other cost related to the purchase of the inventory should be included in terms of the value of the inventory. That should be included in the cost of sales. Okay, this is me. So as you did your assessment and you arrived at the 89,000, it is my understanding at that time. It is understanding at that time that the cost of sales included solely the cost of purchasing the seafood. Clearly, I'm saying, wasn't that your understanding? And he says, when I did my assessment, anything related to cost of sales, as I understood it, was cost of the product, included cost of inventory, cost of the product. I said, okay, so you didn't understand that component as including income to Mr. Fall. I understand it subsequently when I met with Mr. McDonald, which is fine, it falls on the cost of sales. That is fine. And we go on. And it ultimately ends at 547.
Well, there's nowhere in the material that you've taken us to in which it was accepted that the rate was 15%, is there?
Well, not Mr. Rami. The evidence that was given by Mr. McDonald.
No, but I thought you were submitting to us earlier that it had been accepted by him.
Well, he did accept that the cost of sales included commissions and income.
Right, but
Then there is
at no point
another
did he
point.
accept that it was, the appropriate rate was 15%, did he?
Well, I did not admittedly put the rate to him, but the rate had already been given in evidence during the evidence of Mr. McDonald, who had given evidence just prior to him. And in any event, conceptually, he accepts that there is income to the first name appellant, and then ultimately at 547, he does accept that by my specific reference to the but-for test that he used to analyze his loss, that but for the event, but for the freeze, the loss of that commission's income would be a loss to Mr. Forbes. So conceptually, he accepts that. And so we say that certainly that was the evidence that the learned judge had. And the learned judge, being mindful of the fact that Mr. Ramming, had accepted that there was no account given for that commission's income. Mr. Forbes having been awarded a sum of zero, there ought to have been some adjustment.
Well,
Given that,
the evidence which the judge, sorry.
pardon me?
No, I'm sorry,
Should I
given that,
repeat?
you were finishing the sentence. And
Yes, given that the evidence was that the cost of sales included some commissions component.
The evidence from Mr. Raming, whose evidence he accepted, was that there was no evidence put before him to justify the cost of sales. There was nothing that he could say, right, I'm satisfied this was the cost.
Well, Mr. Ramming,
The commission, sorry, not the cost of sales.
Mr. Ramming never said that,
Well,
with respect.
yes, with respect, he said, I only had the documents I was given.
Right.
And that's the only material, and therefore I didn't know about any commission. So he's saying it's not been documented and proved to me.
Right, but bear in mind now, he is saying that, the reference he's making there, as to the materials he had been given, he's speaking about, at that point, the materials he had been given by those who retained him.
No.
When he prepared
with
his...
respect, in his report, he lists the information, which includes the information given by your clients. I mean, the personal bank account would have been a start, wouldn't it?
Indicated, I said to him, he said at the time that he looked at it, that is at the time of preparation of his report, he was not aware of it, of the commission's income,
Well,
as having been contained in the cost of sales.
wasn't in any of the information.
It was not in the information that had been
Sources,
given to him.
I think
And at that point, the only information that would have been given to him would have been the information from the attorneys who retained him.
well, with respect, it's all the disclosures, isn't it? Paragraph 1.26 of his report at 183, page 183.
And that is where he references specific documents being the bundles, the pleadings, and the witness statements.
Witness statements. Well, if this was money, if this was a commission which was going to be an issue, it would have to have been proved. And where it went and where it was paid would have been part of that evidence. So, assuming, as I do, for the sake of argument, it went into the personal bank account, the personal bank account statement should have been disclosed.
Well,
And then it could have been seen.
the personal bank account statements were only presented insofar as it related to the mortgage claim. There was a mortgage contract that was breached.
I think that's my point. There wasn't evidence of the commission receipts, which he needed to.
But the financial component, the financial proof of the claim that was presented by the plaintiffs, now the appellants, was in the report of Mr. McDonald,
Yes, but that's
which is where the
self-serving.
commissions were sent out.
With respect, that's self-serving, and the judge had not accepted Mr. McDonald. We have to start with that.
Well, in the context of Mr. Ramming saying that he was not aware of commissions, the commission's income was set out in the report, saying that of this sum, of this $1 million sum or $2 million sum, there is a component, this is the amount
No,
that's
you
being
can't-
claimed.
The fact that Mr. Raming accepts, as a theoretical matter, that if there was commission payable to Mr. Forbes, that would constitute a separate claim, does not mean he accepts the figures in Mr. McDonald's statement for that commission, because there's no documentation in which he could put his hand on his heart and say, of course, that's the figure.
Well, at that point, he hadn't requested any. He hadn't requested any.
No, I'm sorry, the
He
disclosure
prepared his
obligation.
report and he assessed it. He would have had the report of Mr. McDonald where commission's income was being claimed. He assessed $89,000 being exclusively the loss of profit component. And again, and I think it bears repeating, that he was of the belief that the $89,000 covered all economic activities, and notwithstanding the fact that the commission's income was claimed in the report, there was no reference at all.
But can we just go a little bit further on the question of the material available? Because I think that in cross-examination, Mr. MacDonald said that he'd used the contract with Paradise Fisheries, which showed that he earned 15% of all sales. So I think he told us it was an oral contract, but it doesn't look as if that's how Mr. MacDonald understood it. That's page 436 of the transcript. The second answer on the page. I think it must be cross-examination.
Committee?
6. Have you got it?
Yes, I do. That is actually, lady, a different 15%.
Right, okay, fine.
Because once the sale takes place to Paradise Fisheries, there's 15% of that sale. That's somewhat of a reference to the rate of return that we had spoken about earlier.
Right. So we need to be careful with these references to 15%.
Because remember that we discussed the rate of return also being 15%. So the 15% of the cost of sales is an entirely different 15%.
Fine, so that's the, yes. Okay, I've got that. Thank you.
So ultimately we say that, I'm being reminded that my time is running out. I haven't got to the second component of my oral argument. I was about to say, my lords and ladies, that ultimately, at the end of the day, you do not have in the lower court's judgment, the learned judge, even making a reference to this cross-examination. And so there's no way of knowing what he made of the evidence, what he made of the concessions. There's a very limited treatment of the cross-examination. I think it's probably only 2 paragraphs. And so it would be an entirely different thing, as I had indicated earlier to his lordship, Justice Carr. You know, if the judge had said, I've considered this issue, I don't think that it warrants an adjustment to the amount that has been assessed by ramming because of whatever reason. That would be an entirely different issue. But given the fact that there's no reference to it at all, it's almost as if the cross-examination and the evidence doesn't exist. And we say that that is a problem. Because it certainly is something that would manifestly affect the amount that has been assessed. And certainly from a purely legal standpoint, if and to the extent that there are issues that are relevant to the assessment, that the court has simply not had regard to, regardless of how they may have disposed of it, they simply have not had regard to it, then that is a problem. That is an error. He certainly wouldn't be here if they'd considered it and he'd rejected it. But there's no consideration of it at all.
It is a commonplace, of course, that a trial judge is not obliged to refer to every item of evidence. And simply because there's an omission to deal with a particular point, it's not to be assumed that it wasn't taken into consideration.
Certainly, my lord, and we would say that certainly materiality would be a response to that sentiment. The
Right,
fact
I
is,
understand
insofar as you're talking about a significant amount of income, a significant portion of the claim, a significant, particularly having regard to the amount that was assessed, you look at that, and certainly it is something that, from a material standpoint, from a relevant standpoint, that the learned judge, one would expect, ought to condescend to, even if not favorably. That there ought to be some indication as to how the issue was addressed and what the disposition was. And there is none.
But you hadn't pursued the matter with Mr. Raming in evidence. And was there any application to the judge that if he accepted Mr. Raming's evidence, he would have to allow for a separate claim by?
Well, in our submissions, we invited the court to award the submissions income, having regard to the fact that
That, with respect, is not an answer to my lady's question.
Pardon me?
That is not an answer to my lady's question.
Well, to answer it pointedly, there was no application. Certainly not. But what there was a claim that had been presented for an award that had a component of commissions income. We indicated to the court that the $89,000 clearly only represents.
But you hadn't given disclosure of any documentation relating to it?
Well, insofar as the financial statements had been disclosed and had
No,
been
no,
accepted.
but then this is a personal matter, personal claim, not shown. The documentation which supported it was not the company's.
In support of the commissions, other than the actual report of Mr. McDonald, no.
Just trying to understand.
Yes. And that is the amount that had been assessed as it relates to the commission's income. But the point is, we say that ultimately, when you get to the judgment, specifically paragraph 46, the learned judge, essentially, he did not conduct his own assessment. He accepted the $89,000 as being representative of everything, all of the loss, all of the business, all of the claims, without any regard to all of these other issues. And like I say, there's no way of knowing how he ultimately would have addressed these issues, despite the fact that submissions had been made, and as it relates to those issues. We say, my lords, that when you get to the Court of Appeal level, in addition to the ground that we had already referred the board to, where the Court of Appeal outright essentially did not accept.
Yes, but at the same point, no disclosure, no bank statements, no tax returns to show he got this commission.
No tax. There would be no tax returns.
Well, that would show the
amount of the
yep,
commissions,
the
no. No. Just the evidence, the expert evidence that had been given in support of the claim by the plaintiff's accountant, setting out that amount. And I was about to say, as by the time you get to the Court of Appeal level, you then recognize that in addition to the ground that I've previously referred to, the dismissal of the contention that there was an inability or failure by the court to refer to the other line of business, the court also did not actually, Court of Appeal that is, did not actually condescend either to the extent to which these additional issues may have impacted the award. Again, the judgment is silent on it. And so there's no way of knowing what the court's disposition would have been. And ultimately, the Court of Appeal's decision rests exclusively on the principle that a judge is entitled to determine which evidence it... Sorry?
I just wanted to say that if you had put it to Mr. Raming that he'd made no calculation, and what calculation would he make now he knows it's a separate claim, he would have asked you for the documentation you hadn't produced.
Well, I'm not so sure...
Accepted it was 15%.
I think Mr. Raming's focus was almost exclusively on the accounting component of things.
Yes, well that means seeing the audit trail.
The accounting insofar as, where this commission, from a purely accounting standpoint, ought to have been reflected, whether it ought to have been in the cost of sales or represented someplace else in the financial statement. So it was purely an accounting concern, which is why I kept saying to him, well, quite apart from manner of accounting, as a fact, as a loss, do you accept that this would be a loss to the appellants? And he said that it would be. And so insofar as that loss exists and it's been claimed, there should be some disposition of it. And if indeed the position is that it's refused on an evidentiary basis, then the judgment should condescend to that. But it is absolutely silent as to what should happen to this claim. And it just outright, despite the fact that clearly the $89,000 only related to one aspect of the claim, and also it did not include this commission's income. It just, the court just accepted it without any reference at all to how these issues were disposed of, if at all, or considered. And we say that on that basis, and also from the Court of Appeal standpoint, when you look at the evidence as a whole, the award is disproportionate to the evidence as a whole. And I go back to the bank statements, for example. You go back to the financial statements, for example. And you see, well, and there is also a whole host of other evidence, the mortgage contract, a $900,000 mortgage, overdraft facilities. The award is clearly quite independently of whether or not it was affected by the cross-examination or the refusal to take in, well, the failure, sorry, to take into account these other issues. Quite independently of all of that is also, on its face, and having regard to the evidence as a whole, we say, disproportionate to the level of transactions that clearly was transpiring. And we say that from the Court of Appeals determination, that again is an analysis which ought to have occurred. You see that the Court of Appeal canvassed the authorities and quite clearly accepted what its obligations and its duties were in reviewing a lower instance assessment. And yet, after having said that one of those obligations was to consider whether or not the award was either an erroneous estimate or disproportionate to the evidence as a whole, having accepted that that is a role that it ought to play, it never in fact did that. So again, we look at the Court of Appeals decision, and there's no way of knowing what the Court of Appeals view was as to the accuracy of the award, the proportionality of the award, or anything of that matter, because the court did not at all condescend to that issue, even though the authorities all demonstrate that they ought to also carry out that analysis. There's no way of knowing how the Court of Appeal, other than saying that a lower court judge is entitled to decide which expert they prefer. There's no way of knowing how the Court of Appeal got to the point of not interfering. It made a determination that it would not interfere with the award, but there's no way of knowing how they got to that point, other than by reference to issues which were not issues that the learned court had based its assessment on. One of those issues was lack of independence. Again, you look at the lower court's determination and the reason for the acceptance of Ramming's assessment. And at no point did the lower court judge say, I accept this $89,000 assessed amount because Mr. McDonald lacked independence, or that anyway this was a factor that formed the basis of the acceptance. And yet you have the Court of Appeal, to a large extent, making reference to issues of independence when that was not the basis, not only of the lower court's assessment, but also it was not the basis of an objection from the respondents. And so we say that from the Court of Appeal standpoint, it did not, we say with respect, carry out its duty, as the authorities all suggest that it has to. That duty being not just to make a determination as to whether or not that right exists of making a preference between the competing expert evidence, but also a determination of the award itself, a consideration of the award itself. And it is on those grounds, we say, that both judgments, the lower court assessment and the Court of Appeal judgment, ought to be set aside. Now, I had intended to go on to the issue of assessment, but I'm being told that I may not have the time to do that. I don't know how I ought to proceed.
It's a matter for you. You have half an hour for your reply. If you want to eat into some of that time just now, then you can do so. but obviously you'll have less time available for your reply in that eventuality.
And I'm thinking my preference would be to have the right of reply. I don't know. I do know that my written case does condescend to methodologies for the purposes of assessment.
Yes.
For that purpose, we can then rely on those methodologies. What I would say before taking my seat is that certainly there is a methodology too as it relates to the Paradise Fisheries business.
Yeah.
And we say that one of the points that the board would see in the transcripts is that the respondent's expert had many things to say about the financial statements, their reliability, and essentially advancing the position that they ought to be used for the purposes of assessment. And it is that which has transpired with methodology 2, utilizing the financial statements to arrive at an award based on the amounts that are in those statements. And that is what we would refer for the board's consideration. Other than that, given that my time is up.
Yes. Well, you can take it. Obviously, we've read the written arguments, and we'll
Yes.
consider all that's set out there carefully.
Yes, I'm obliged.
Thank you very much. Ms. Ferguson, do you follow? Is there anything you want to add? Thank you. Mr. Slater.
My lords and my ladies, I appear for the respondent. I had planned to address the board by reference to the structure of our written case, which for your note is at 429.650, and I remain happy to do so. But in view of the way the argument has developed this morning, I wonder whether it may be of greater assistance to the board if I was to make submissions about the only two really live issues, as it appears to me. Those issues being, in my Lady Arden's words, the lack of audit trail under JJ Seafoods and Paradise Fisheries. I'll take them in that order, if I may. In relation to J&J Seafoods, the best place to start may in fact be with the question which my Lady Arden put to my opponent, which concerned the Raming report, particularly page 191 of Raming, and that is behind tab 14. At the first line of paragraph 327. It had been made an argument that Mr. Raming was wholly unaware of what was being claimed in relation to J&J Seafoods and Phil's Seafoods at the time that he wrote the report. My Lady Arden put to my opponent that that was incorrect by reference to the first line of paragraph 327. My opponent, no doubt inadvertently, said that that related to a different head of loss than the head of loss being inquired about by my lady. But I respectfully submit that that is inaccurate. And one can see that by turning over a couple of pages to 253 and 267. 253 is behind 18, as is 267. The point I'm going to put to the board is that the number referenced there being 2.102 million Bahamian dollars, which was considered by Raming in the report, paragraph 273, is a reference back to the head of loss in relation to JJ Seafoods. And one can see that. It's just that it's differently described on 253. It's the antepenultimate number at the bottom of the page, 2102 spot 256. My submission is that from that document alone, one can see, unsurprisingly, that Raming was well aware that the JJ Seafoods issue was something which was being considered by McDonald and was therefore something which he had to consider. But there's more. If I could ask the board to turn forward to
You go back to 3.8,
Sorry, my lord.
187.
Yeah.
Where he lists the claims, includes that one as item 3,
Yeah,
and says no supporting information provided.
absolutely, my lord. And the number is exactly the same. There's no doubt it can be any other head of loss. And since my lord asks about information that's missing, perhaps it would be useful to take the board briefly, and I'll come back to 267, but just to answer my lord, could we please go to 219? That's Raming as well. So 219 is a list. At the bottom of the page, there is a list of the documents which he seeks in relation to Paradise Fisheries, but further up, under Forbes Seafood, which we now know is the 2.102 million Bahamian dollars. Does my lord have it?
Yeah, and he set this up as Appendix 4,
Exactly.
page 206.
Exactly. So there's a full list. At the beginning of that list are some general observations about the fact that, Mr. MacDonald should have put in a CV and various other, what one might call procedural shortcomings in the claimant's expert report, and then he goes into the substance. So, one can see from the bullet points that there's clearly quite a few points on which, in his view at least, there were omissions. We now know that Forbes Seafood is the terminology by which Raming refers to the 2.102 Bahamian dollars. So 207, my lord, second page. My lord's got the point.
The one we were looking at before, 219, was headed unsupported claims of the plaintiffs. Is that
Exactly, my lord.
is that the only page that's headed that?
219.
Yeah.
So that is a summary, my lady, of what one sees at 206 and following, being, as my Lord Hamden pointed out, Appendix 4.
Which he refers to in the body of the report.
Exactly. So, and I'll explain this more fully when I come to make submissions about the Paradise Fishery problems and the lack of, quote, audit trail on that. But does my Lady Black have it? 206, Appendix 4.
Yes, it was just the, he called them unsupported claims. That was what I was wanting to look at. That's fine, we've done that.
I mean, that's a reference back to the terminology that he uses in the body of the report,
Yes.
itself. I was asking the board to turn to 267. Sorry for all the jumping around. Worthwhile spending a couple of minutes on this page. So, as can be seen at the top, Forbes Seafood is the terminology which is used by MacDonald, and it's then adopted by Raming at paragraphs like 237, to which I took my Lord Hamden just now. The figure of 2.102 million is plainly the figure which is in Raming's contemplation at paragraph 237. So my submission is, even from those documents alone, and I'll go now to what the trial judge says, but even from those documents alone, it is thoroughly clear that what MacDonald had referred to as the Forbes Seafood losses was incorporated in the consideration of Raming. And we also know, in my submission, that what Raming said about that was, it's all very well, but there is no supporting documentation whatever. So sticking with this lack of audit trail in relation to J&J Seafoods, could we please turn up the trial judge's judgment, which is at 4:25.
Sorry, 425.
4/24. Well, 4/24, my lords. Let's start a page back. Paragraph 11. So we've established from Raming and MacDonald that whenever we see a reference to 2.102 million, that is the non-Paradise Fisheries loss being claimed. And with that in mind, my lords and my lady, may we look at paragraph 11 of the trial judge. The plaintiff suffered a loss of 2.102 million. We know what that is, i.e. non-Paradise Fisheries losses. He has something to say about the soi-disant methodology of MacDonald. He uses the cash flow as a base, etc. Over the page, those statements show a corresponding credit. We can come to that if we want. And the entry also shows an offsetting debit. We can come to that if we want. Those are behind tab 16 and 17. There again, one can see that the trial judge is considering exactly what the claimants are putting forward in relation to the Forbes seafood loss. So from those 2 points alone, the trial judge's consideration and what MacDonald has to say and what Raming has to say, our submission is that it cannot be right, as has been submitted this morning, that the trial judge was unaware of the J&J Seafoods claim. There's more. So this morning, my Lord Hamblin taxed my opponent to show where in the pleadings there was any reference to the J&J Seafoods. None of these claims are separately pleaded. It's admitted in the appellant's written case before the board that, as was admitted orally, that there are no financial statements whatever in relation to J&J Seafoods, and the reference to the appellant's written case is 4/28642. So those are our submissions on the claim that, the allegation that the judge overlooked the J&J Seafoods matter. The mere fact that the judge is talking as he is at 11, 12, 13, 14 and 15 about the different bank accounts makes it quite clear in my submission that he was aware that one bank account related to Paradise Fisheries and the other one related to the other business. Turning to Paradise Fisheries then, the claim is, the fundamental claim is, that because Raming was unaware that some income in favour of Mr. Forbes was hiding in line 2, namely the cost of sales, that the judge also was unaware of that, and that Raming was unaware of that at trial. Now, it is true that at the time he wrote the report, Mr. Raming didn't know about the Paradise Fisheries Commission claim, and that's perhaps not surprising because, as we discovered this morning, it's not pleaded. In the written evidence of Mr. Forbes, that's to say his supplementary witness statement, he has 2 short and somewhat imprecise paragraphs about Paradise Fisheries, and they are 2:13:168. Could I invite the board to turn those up? The agreement was for me to purchase between £150,000 and £200,000 during the lobster season, which is not exactly a model of precision in my submission. The agreement, again and precisely expressed, would have netted me approximately Bahamian dollars 375 to 500. Ms. Rowe was asked, is there any supporting documentation in relation to Paradise Fisheries? She said no. The correct answer is, actually, there is some underlying documentation, and it is a letter at 272 behind tab 19.
I'm sorry, give me that reference again, please.
My Lord, forgive me.
No,
Tab 19,
Yep,
273.
270. Thank you.
And I draw attention to the date at the top of that letter. I'll just wait for my Lord Hamblin to finish reading it. As we know, Raming put in his report on the 27th of January. It contained in Appendix 4 that long shopping list of things which he would have expected to see, but surprisingly he hadn't seen. There were then 4 meetings and 2 telephone calls between the experts, as a result of which MacDonald, it appears, tried to make good the errors that Raming had identified in his document. And this is one of the documents, indeed it is the only document in relation to Paradise Fisheries or J&J Seafoods, which was subsequently provided. I'll come in a second to the Herculean efforts which in our submission Raming went to try to get MacDonald to cough up further documents. But this is one document. So that's Forbes's written evidence. There's also Forbes's cross-examination. And the board will remember that the point I'm trying to deal with is that the judge was unaware, and Raming was unaware, that Paradise Fisheries Commission was a live and important issue. In fact, of the 66 pages of Forbes's cross-examination transcript on the first day of the trial, 21st of March, fully 25, nearly 40% of that was given over to the Paradise Fisheries issue. It's tab 21, 355 to 370. I don't invite the board to pull that up. But what it does show in my submission is that it is unarguable that this matter was not fully explored at trial and fully explored in the oral evidence.
So he's claiming that because of the freezing of the North Andros and the two accounts we've looked at, because of the freezing of those accounts, he lost commission as an agent employed by a third party. That's right. Yeah.
And I'll come in a second to make the obvious points, most of which, frankly, have been made by my Lady Arden, which is, you know, these are claims by Mr. Forbes in his personal capacity. Where are the tax returns, bank statements, invoices, blah, blah, blah? In fact, all the things which Raming asked for in Appendix 4 of his report. So we've got Forbes's written evidence, we've got Forbes's cross-examination. My submission is that it was fully explored at trial. Indeed, that's clear from 25 of the 66 pages of the transcript. And my submission is that whatever problems Raming may have had at the time of his report, I emphasize at the time of his report, in seeing the full picture, there can be no doubt that the judge had the full picture in front of him, and that's the thing that matters. Turning next to Raming's report itself.
So this is the claim he's bringing in respect of a breach of contract between other parties, between the bank and the companies, and he's seeking damages for a breach of their contract.
Well, I think that what he's claiming is that because we froze his accounts, he didn't have enough money to be able to perform one of the two options that he had under the Paradise Fisheries contract. Because either he could buy with his own funds, in which case, as page 272 tells us, he gets $2.50 as a spread, as a margin, or if he uses their funds, he only gets $1.50. So I think what he's claiming is that because he didn't have access to the money in his accounts, which in fact was a credit line rather than a debit balance, credit balance, he was unable to perform his functions as a buy-side agent for Paradise Fisheries. And therefore he lost the difference between what he could have got if he was buying with his own money and what he was doing, buying with their money.
Yeah. Well, I appreciate the point I'm raising. It's just something that's just occurred to me that the only account of his that was frozen was the one to do with the house works he was having done.
That's right, my lord. Yes.
And for the rest, he's not the account holder of the accounts that were frozen in breach of contract, but he suffers a loss in his capacity as an employee of a third party.
Yes, I mean, I don't want to be too hammy about this, but the fact that we're struggling to work out precisely what the nature of the claim is not exactly supportive to the appellants. In relation to Raming's report, which we went to earlier, might I ask the board just to have another quick look at that. We've looked at the page which talks about outstanding items. That's 219. A similar list is at 186. Might I ask the court to have a quick look at that? So what we have at 186, 184, forgive me, it's very difficult to read the number. Paragraph 2, spot 7. This is a general criticism of the lack of evidence which has been provided. So in relation of most of the loss of profits claims, so speaking more generally at this stage, supporting information was not provided, nor was any sufficient supporting information provided to allow for an independent calculation and verification of the claims. Now, 206, which we have already been to, is the beginning of the list. But the key thing for Paradise Fisheries is 2 pages over, 208. And it's under the heading, Loss of Profits Relating to Paradise Fisheries. What he wished to see, essentially, were the issues which the board has been inquiring about this morning. Signed agency agreement, detailing purchasing volumes and pricing, those sorts of things which one would ordinarily expect to find in a loss of profits claim. And as my Lady Arden will remember from the Ramsden case that she made a decision in that case, as also in the Parabola case that was cited, of course one has detailed, audited evidence of what the companies or persons have been making in the years prior to the asserted breach. That's all pretty vanilla stuff. It's set out in the first half of our written case, and I don't propose to take the board to it. I mentioned earlier that Raming engaged in what I described as Herculean efforts to try and get MacDonald to explain what the true evidential picture was. There were 4 meetings, there were 2 telephone calls. Obviously, I'm not going to refer to the contents of those. But in cross-examination, Raming said something which I think is interesting about what's
So I'm going to call it right there. I am going to look and see if I can find the other part, if there's any other parts to this. I know the UK Supreme Court stuff, it's just been piling up good content for me for the channel. Now, everybody, if you like the content, the court content that's on this channel, and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. And to everybody who comes on here and watches my content, and I really appreciate it. I really appreciate you guys. I really do. I want to thank everybody who watches my content. You really have you really helped me make a decision that I'm going to keep doing this no matter what. And if people don't like it, tough, you know. But again, like I said, if you're not a subscriber to this channel and you like this court content, please do me a big favor and subscribe to this channel and help this channel grow. Let me get this ready here, and oops. All right. Let me turn that down a little bit. Okay, so that's it for today, everybody. You all have a wonderful evening. Ciao, ciao, and ta-ta. And I'm still trying to get used. Please be patient with me. I'm trying to get used to Restream. I'm used to StreamYard. but I'm trying to get used to Restream. So everybody have a good evening. Ciao, ciao, and ta-ta, and I'll see you guys tomorrow. Bye-bye.